I'm not sure how to follow that. But what I'm going to say is that even if you don't care about access to courts, and even if you don't care about civil rights plaintiffs, I'm going to give you 5 reasons why members of the Federalist Society in particular should oppose both Iqbal and Twombly. Because I believe, and I'm going to explain why, that Iqbal and Twombly are contrary to everything that the Federalist Society stands for. So, the Federalist Society is committed to, among other things, an originalism as a method of interpretation. And as Suja Thomas showed, this is Iqbal and Twombly are inconsistent with the original intent of the founding generation in enacting the adopting the Seventh Amendment. And as Steve, I think, briefly showed, and as he has showed in his writing more fully, it is also inconsistent with the original intent of the drafters of the Federal Rules of Civil Procedure. So we essentially have we have an interpretation of an illegitimate interpretation of the Constitution by Federalist Society standards, and an illegitimate interpretation of a statutory product by Federalist Society standards. The Federalist Society is second committed to allocating authority to the people and their representatives rather than to judges. And in deciding the cases, as Steve suggested, the Supreme Court usurped the authority of Congress and its delegated agents under the Rules Enabling Act. And as I think Suja implied, the consequence of the cases will be to transfer power from juries, from the people, to judges. So again, the second commitment second Federalist Society commitment that Twombly and Iqbal are inconsistent with is the commitment to give authority to the people and their elected representatives rather than to unelected federal judges. This does exactly the reverse. Third, the Federalist Society is, I believe, committed to reducing judicial discretion in particular by the use of clear and formal rules. Justice Scalia is obviously one of the strongest advocates of both the reduction of judicial discretion and the use of clear and formal rules, which makes it somewhat ironic that he joined both the Twombly and Iqbal majorities. And I think, as I said, the cases are inconsistent. They will increase. First of all, it is not a clear and formal rule. As Steve said, plausibility is a wholly new standard. If you look at the lower court cases, lower court judges have no idea what to make of the standard. They already have difficulty deciphering what Twombly and Iqbal mean, much less applying it. So it is not a clear and formal rule. And I think that it will increase judicial discretion. One of the ways to define judicial discretion, particularly at the district court level, is to ask whether there's likely to be oversight. Are the courts of appeals likely to police the discretion of the district courts? If not, then the district courts are going to have more discretion. And I think one of the things that Twombly and Iqbal do is make it highly unlikely that a district court judge will be reversed no matter what she does, whether she grants the motion to dismiss or she denies the motion to dismiss. In most cases, either that decision will not be appealable at all, or the standard of review will be such and the standard of the motion will be such that a court of appeals is unlikely to disturb the district court's decision. So the combination of an unclear rule and the decrease in oversight is going to lead to a tremendous amount of judicial discretion. Fourth commitment, I think, of the Federalist Society is to reducing the cost of litigation. And I think that these cases are more likely to increase the cost of litigation on both sides, but especially for defendants, because what used to be a routine but basically unimportant motion, that is, a 12b6 motion was made in every case, but it was a throwaway motion, no lawyer time was expended on it, it was boilerplate, it was not expensive. Now that routine motion is going to become fiercely litigated in every case on both sides. And although some of those cases may be dismissed, and again, here we go back to the lack of clarity of the rule and the increased discretion, it's hard to tell how many of those cases will be dismissed. Some of them will be dismissed, but I don't think enough of them will be dismissed to offset the increased cost in every case as the motion to dismiss becomes a major battle instead of a minor and routine skirmish. Fifth, I think the Federalist Society, and most specifically, the Federalist Society is committed to deterring frivolous litigation, and I think in one sense that is the strongest justification that has been offered for Iqbal and Twombly by both the court and its defenders. But I think paradoxically there is a good chance that these decisions will increase truly frivolous litigation, and by that I mean litigation that's filed in bad faith. That is, litigation where the plaintiffs pretty much know that they don't have a case, but they figure that they can extort a settlement by filing a case. Now, it may reduce some litigation or get rid of very early some litigation that is weak, but not bad faith, not frivolous. So why might these decisions increase the filing of truly frivolous bad faith litigation? It's because the information on whether the bad faith plaintiff's gamble will pay off comes earlier, before the plaintiff has expended very much. So it used to be that for a bad faith plaintiff, a frivolous plaintiff, a plaintiff who was playing only to extort a settlement but knew that they had no hope of winning, for that plaintiff to prevail, that plaintiff had to be willing to pay the costs through summary judgment motion. Now, those costs might not have been as much as the costs on the defendant, but there were costs. Now, such a bad faith plaintiff going in only has to pay the costs through the motion to dismiss. And if the motion to dismiss is granted, well, you tried, you lost, that's okay. But if the motion to dismiss is not granted, that sends a powerful signal, and the case will almost certainly settle. Basically, so plaintiffs who have actual cases but somewhat uncertain may be deterred, but the plaintiffs who are just playing the game to see if they can bluff to a win will not be deterred, because essentially what the court has now done is reduced the initial ante. The initial ante used to be a willingness to litigate through the summary judgment stage. Now the initial ante is only a willingness to litigate through the 12b6 stage. Basically, they get to see, these bad faith plaintiffs get to see more cards before they have to pay the big bet. And so they're going to be more willing to do that, which is why I think there is a good chance that the truly frivolous litigation, as opposed to the maybe weak, but we don't know litigation, the truly extortionate litigation is likely to be increased under this standard rather than decreased. Now, I don't know whether there's actually a problem with frivolous litigation, but if there is, I don't know what the answer is, but I do know that if there is a problem with frivolous litigation, this is not the answer to it. Thank you.